right. Hey, welcome everyone. I'm Dr. Darin Detwiler, and this is going to be one of the earlier videos you watch in our series of videos on recalls. And the whole idea here is that there are so many things to cover, and not everything is covered in textbooks. And even if it is covered in textbooks, sometimes those textbooks are already 10 years old, even if it's a newer version of the textbook. So to have a variety and diversity in the voices we bring into this, talking about these elements, it really makes this, at least for me, a very more valuable way of looking at content within this course. We're talking about recalls, as you know, and I am here with someone who I consider to be an expert in recalls. Amy Philpott, she and I have been on stage together. We were just recently in Cleveland, Ohio at the International Association for Food Protection Conference, and we work in some similar circles and on some similar projects in the area of not only of food safety, but specifically of recalls. And I'm really excited to welcome her to, I was going to say our stage, but welcome her to our video. Amy, welcome.
Darin, thanks so much for having me. It's a pleasure to be here and talking about recalls.
Excellent. Well, for those students who have no idea who you are, we give us a little taste, if you will, of what's your background and what do you do?
Sure. I currently own my own public relations firm in Washington, D.C., and we focus exclusively on the food and agriculture sector. So, all of the companies that I work with are in the food supply chain, and many of them are in the pre-retail, the what we call farm gate area of the supply chain. So, farmers, ranchers, food processors, manufacturers. So I work primarily with industry companies and I help them with their recall communications and their recall management to help them prepare for, execute, and recover from food safety recalls.
You know, most people, when you hear recalls, you start thinking like science and laws and policy and regulatory compliance and retail and economics. But I got to admit, if you're not thinking about communication when it comes to recall, you're missing you're missing a big picture, a big picture. I'm sorry, I will cut this myself.
Yeah, I'm
Uh,
hoping you'll do the same for
yeah,
me
oh
in
yeah, yeah,
cases.
yeah. Um, you know, when most people talk about recalls, they start thinking about laws and policy and science and economics. But if you're not thinking about communication, you're missing a huge part of the picture because everything about recalls is communication in one way, shape, or form. Tell me I'm not wrong.
No, I can't tell you you're wrong. You're absolutely right, Darin. And it is emphasized in regulations, it's emphasized in compliance documents, and just good practices. So if we look on the regulatory side, FSMA, the Food Safety Modernization Act, has in its law that companies have to have a recall plan, and in that recall plan, they have to identify persons who will be responsible for communicating with their customers, with consumers if it's necessary, and to communicate within the company about things like product disposition. So it's in the regulations, it's good practice. And the compliance officers will be looking to see that you have this or that industry has this in their recall plan.
You know, I got to tell you, one of the most common questions I get from media, if I'm contacted by a newspaper or magazine or television news station, when there's a news about a recall from a retailer, they'll ask me things like, you know, what's the first thing that comes to mind when you see that a retailer is communicating to the public about a recall? And my first thought is that things are working the way they're supposed to be working because I would think horribly if I found out that a retailer was not communicating about a recall. That I think it's strange when there are folks out there that they have different opinions about communicating about recalls. So I'm really glad that we're able to talk about recalls. And the purpose of this video is really to kind of look at some foundational elements And I kind of think of it in terms of if if journalists, if those who work, especially in retail and restaurants, and quite honestly, even if consumers knew some of the things that we're going to talk about here today, perhaps there would be a better overall understanding about not only before a recall or during a recall, but even after a recall. What communication is taking place there?
Darin, thank you again for having me. I'm excited to talk about recalls. I know that probably sounds strange, but I live and breathe recalls daily. So the opportunity to share just basic information, even about recalls, is something that I'm happy to do. So the first thing I want to do is just touch on the types of things that I'll be talking about. I'm going to introduce the regulatory and legal underpinnings of a food recall, what a food recall is in the first place, the expectations of recalling firms, risk or recall communication principles, and then finally, what the food supply chain, what growers and farmers and manufacturers and processors of food can and should be doing to prepare for a recall. So, under the regulatory and legal underpinnings of a recall, I want to touch base on the Food, Drug, and Cosmetic Act, specifically Title I, Chapter 9, which addresses prohibited acts. Now, if you want to look at the FD&C Act in its entirety, you can just go to Title I, and you'll see the entire code. Chapter 9 tends to deal with prohibited acts. And it's important to understand this because this is what gives the government agencies such as FDA and USDA the authority to work with companies when a product is potentially harmful to public health. And I'm sure everyone can read this, so I'm just going to summarize it. There are many prohibited acts, but some of them are particularly pertinent to the discussion today. The first one is it's prohibited by law to introduce or deliver for introduction into interstate commerce any food that's adulterated or misbranded. Not only that, but it's prohibited to actually adulterate the product. It's against the law to receive adulterated product. So what that means if there is a product that's out in the marketplace and it is either proven or it is thought to be harmful to public health, then all of the companies in that supply chain that introduced the product, delivered the product, received the product, and may have had a participation in how that product became adulterated in the first place, they've all broken the law. Okay. There are other things in this section as well that some people may not think would be in there, but the refusal to permit investigators to look at your records, or to refuse to allow entry to conduct an inspection is also against the Food, Drug, and Cosmetic Act and would be considered illegal. And it's important to know that, especially if you are a food company, you need to know exactly what those prohibited acts are.
Uh, and I'm not looking at my notes here, but when you typically look at some of the more mainstream headline gaining incidents
Mhm.
and the ones that typically you have the large federal fine for an outbreak or recall, you typically see one of the first charges they mention, if not the only charge, is that Part A there, the idea of introduction into interstate commerce of adulterated or misbranded food. That's quite common, correct?
It is. The first one, the letter A, is quite common because it's the easiest to prove.
Yeah,
So that does oftentimes act as an umbrella for everything else.
yeah.
Okay, so what is the potential implication of violating the Food, Drug, and Cosmetic Act? There are two criminal liability levels that the Act provides for: misdemeanor liability and felony liability. And under the misdemeanor, it's typically, or it can be, up to 1 year's imprisonment and $100,000 for fine for individuals and $200,000 fine for corporations. Under a felony liability or felony prosecution, it's up to 3 years imprisonment with 250,000 and 500 for individuals and corporations, respectively. The important thing is here, each shipment is a separate offense. So if a company shipped 5 containers, each one of those is considered a separate offense.
So this would probably explain why, when you talk about the idea of each shipment and that it's just this one, one charge, right? When you look at certain cases where obviously they're paying a lot more, right? I mean, we just had what, the $47 million for Family Dollar and the 25 for Chipotle, and you start looking at those larger amounts. Well, you're looking at multiple charges, multiple offenses, multiple elements that are all kind of coming together, and also the fact that you may have an FD&C Act misdemeanor or felony, but you may have other
Yes,
non-FD&C Act
yes,
charges. And, for instance, we're about to hit the 10-year anniversary of the sentencing for the Peanut Corporation of America. And
right.
that was a company that those executives faced everything from obstruction of justice to wire fraud to,
Mail
yeah.
fraud, wire fraud, yeah.
So it's the kind of totality of all of the various charges against them, of which this may be a portion.
Yes, exactly. So I'm just talking right now strictly about the
Right.
FD&C Act, but yes, you're absolutely right, Darin. There are many other penalties and fines and a liability that can be levied against a company. Okay, so let's look a little at the legal background because some people would say, "Wow, that can be pretty hefty. Where did this come from?" So I'm mentioning just a couple of court cases here, and because I'm not a lawyer, but I hang out with a lot of lawyers, I have a disclaimer at the bottom. So please, this is for information purposes only. And if you need a lawyer, call me. I can recommend one, at least in this area of expertise. So in the first court case, United States versus Dottervich, this is a 1943 case. So it came within about 10 years, maybe less, of the actual establishment of the Food, Drug, and Cosmetic Act. So it was one of the first tests for the act itself. And in this case, the courts dispensed with the requirement for criminal conduct. That is, they said that a company didn't have to be aware of any wrongdoing in order to be found liable. So, in other words, it provided for strict liability. Then in 1975, there was a case called United States versus Park, and Mr. Park owned a warehouse. And I can't remember if it was in New York or Chicago, but it was in a port city. And Mr. Park's warehouse had been cited several times for being dirty and filthy, and they were warned that it needed to be cleaned up, and it wasn't. So, in this court case, Mr. Park was taken to the Supreme Court, where they ruled that the senior most authority of the company is responsible for correcting any violations as they occur. And it didn't matter that Mr. Park never received any notice of the violations, had never even visited the warehouse, but was in fact the owner of the company and therefore liable. We also saw the same sort of ruling in the DeCoster case, United States versus DeCoster, where Mr. DeCoster was found guilty of um, having a dirty chicken farm that resulted in salmonella outbreaks. So, um, so up until recently, strict liability has been pretty much the rule for food safety contamination cases. And that includes companies who issue recalls. And even though you issue a recall to try to get the product out of the market, you can still be held liable under these strict liability court cases or case laws. However, May 9th of this year, May 9th, 2025, there was an executive order called the Fighting Overcriminalization in Federal Regulations. And it has the potential of affecting the Food, Drug, and Cosmetic Act, and specifically the strict liability application of these laws. And what this executive order does is it directs agencies to consider civil rather than criminal enforcement of strict liability regulatory offenses, especially in cases where it can be shown that the company was not aware or did not intend to cause harm. So it's still not clear exactly how this is going to play out in practice, but it does appear to potentially change the strict liability conditions under which companies have operated under since 1943.
It will be interesting to see how this plays out with certain cases that are going on right now. There's been certain comparisons, like you made the comparison between the Park and the DeCoster case. You can make similar comparisons with the Family Dollar Store and clearly with the Peanut Corporation of America and with Boar's Head, and how those play out. I think it ends up sending a message. Whether that is a message of deterrence or a message of accountability or a message of, hey, this is where the line's drawn, and now I know where I can act as a leader. I think that there's some confusion there because those lines are either blurry or keep moving. But I really appreciate how you characterize this idea of we're in a bit of a limbo state with this new executive order from May of this year. But kind of like you have that disclosure at the bottom there. I guess my kind of disclosure would be I would not want to be known for having a legacy as a leader, as someone who found the loopholes or found the reason to justify doing things that otherwise would be immoral, unethical, illegal, whatever kind of a thing. I love the fact that there are plenty of companies, plenty of examples, and I know that you and I interact with some great people from great companies that they look at these things as like the minimum, whereas they hold themselves to higher standards. And I always appreciate those companies that hold themselves to those higher standards, even if they're in an environment or a period of time where the standards can be lower.
Yeah, exactly. And it's a good point. There's the business license to operate, which regulatory and legal liability falls under, but there's also the social license to operate. And just because a company may not be held criminally liable for something doesn't mean that their social license, the acceptance from their consumers and from the outside world, even their customers, isn't going to be affected. So,
Yeah.
and certainly it's not the only thing that needs to be considered. And I agree with you, Darin. I just from an ethical perspective, the companies that I have worked with and are working with, and will work with in the future, they have to have the perspective that this that what they do, they have to have the perspective that what they do goes way beyond the minimum requirements and even the legal requirements, that they have to do the right thing. So that, I think that's the most important thing. But I set all of this up because next we're going to talk about what is a food recall. And within that discussion, we're going to talk about the types of recalls. And when we get to that point, I will remind you about some of the things we've just talked about under regulatory compliance.
Well, Amy, thank you very much for this. We're going to end this as part one, and I hope that people, when they come back for part two, where we're going to talk about the different types of recalls and kind of define some of those key terms, I'm really looking forward to continuing this conversation.
Me too.